Very beginning, I want to introduce myself. My name is Tatjana Zoroska Kamilovska, assistant professor at the Faculty of Law in Skopje, Macedonia. For the purposes of this scientific conference, as it said in the program, together with Professor Arsen Janevski, we prepared the paper concerning the notarial deeds in international legal relations. As you can see from the conference materials, our paper contains also the special review or overview to Macedonian law and practice. But since we have a time limitation now, I will not go into detail in these questions, but just to discuss some general issues. First of all, why do you think that the topic on the position of notarial deed in international legal relations is so crucial or let's say important in the context of the theme of this conference, which is cross-border legal proceedings in EU. I will simply answer that the significance of this topic derives from the mission that the notary has in the current globalization phenomena, and that is to provide for efficient cross-border legal relations and legal certainty in international transactions. I want also to recall that today notary covers not only notarization activities, but also a large number of functions in the area of non-contentious administration of justice, including the matters with cross-border element. The realization of the above-mentioned mission, notary mission, no doubt implies the free circulation of notarial deed in international relationships. No doubt approaching the issue of free circulation of notarial deed in international legal relations, we should start from certain premises. First of all, the trend of globalization understood as freedom of individuals and companies to initiate voluntary economic transactions with citizens of different countries presupposes revocation or at least minimization of the obstacles that inhibit the international legal relations, including the relations with notarial deeds. But besides this, it's a fact that cross-border relationships are still burdened with different kinds of obstacles that inhibit the free circulation of goods, people, services, as well as notarial deeds. Taking into account these fundamental premises, our analysis was focused on the question how to satisfy the need to recognize universal effect of notarial deeds in cross-border relationships. In answering these questions, we analyzed the current mechanisms for providing external efficiency of domestic notarial deed and respectively the mechanisms for internal efficiency of foreign notarial deeds, and we suppose that these analyses should lead us to answer whether further liberalization of the legal regime of the international relations with notarial deeds is necessary in order to provide the notarial deed with fidem and authoritatem, not only within but also outside the state borders of the country of origin. The paper starts with the definition of the notarial deeds, followed up by elaboration of some effects of the notarial deed. It is well known that the core area of notarial work is so-called regulation certificatory function, which comprises the official composition of deeds for legal matters and statements or declarations with which certain rights are established. The definition of notarial deed, which comprises the different kinds of notarial deed, is more or less equal in all Latin notary countries. In this sense, notarial deeds are deeds for legal matters and statements drawn up by the notary in the form of a notary act, then minutes for legal matters composed by the notary or which have been composed in his presence, and as well certificates for facts which the notary has confirmed by direct observation or by means of documents. As the effects of the notarial deed are concerned, I want to stress that the questions on effects of notarial deed can only be posed and at the same way answered only from the perspective or from the viewpoint of a particular legal system. In that sense, within different legal systems, usually more legal effect of the notarial deed can be identified, but from the aspect of international legal relations with notarial deed, we narrowed our elaboration on, first, the evidence effect of the notarial deed, then the notarial deed as an enforceable instrument in international legal relations, and in addition we review the question on composition of notarial deed in matters with cross-border elements. I will start with evidence effect of notarial deeds and with the widespread statement that public deeds, including notarial deeds, are one of the most commonly used and at the same time particularly secure means of proofs in legal relations, both in judicial and administrative proceedings. In respect of evidence effect of notarial deeds, in different legal systems, different evidentiary rule applies. In Latin notary countries, the evidentiary rule for veracity of public, including notarial deed, applies, and this means that the notarial deeds give full evidence of the operation that has been notarized by the notary, and in the specific provision, this rule limits the principle of free appraisal of evidence. This assumption of veracity of public, including notary deeds, does not apply in the countries that are not familiar to the Latin notary country, for example, USA, England, Sweden, and others, because these countries, in their procedural law, do not have the evidentiary rule that gives the notary the bigger evidence effect than other evidences. I will further limit my elaboration on the first group of countries, Latin notary countries. As I said, in these countries, the evidential proof or veracity of the public or notarial deed applies. The assumption of veracity of public notarial deeds arises from the assumption of authenticity or originality. For the domestic public deeds, the authenticity is presupposed unless the body, in an appropriate proceeding where the deed is used, suspects the authenticity. But when it comes to foreign public deeds, then most of the countries today allow for the foreign public and notary deed to be used on their territory with the evidence effect of a public deed, provided that it is appropriately verified, unless otherwise provided in an international agreement. This condition, the foreign public deed should be appropriately verified, in fact refers directly to the assumption of authenticity or originality, or it refers to the mechanisms for conducting the authenticity of the document. It is well known that the most traditional mechanism is legalization, and at the same time it is the most complicated one, because the procedure for legalization itself implies the involvement of multiple bodies: diplomatic body, court, administrative body, with a few chain of validation and supervalidation or confirmation, and this considerably complicates and delays the proceedings. The legalization is not carried out when it has been abolished on bilateral, regional, or multilateral level. I will start with multilateral level, and here I will mention the well-known Hague Convention abolishing the requirements of legalization for foreign public documents of 1961. And this convention provides for only one formality, which is issuance of a certificate or apostille by an authorized body in the state from which the document originates, at the request of the person who has signed the document or any bearer. This certificate is considered to be sufficient evidence to the originality of the deed, and it is well to know that this certificate is not required when either the laws, regulations, or practice in force in the state where the document is produced, or an agreement between two or more contracting states have abolished or simplified it or exempt the document itself from legalization. Of course, the apostille is not the final solution of the international community for the need to prove the authenticity of the documents. It's worth to mention the efforts for further simplification of the formalities for ensuring the authenticity of the deed. For example, I will mention the possibility to place an apostille not only on the original document, but also on its certified copy, and also the electronic issuance of an apostille of public notarial deeds in some country, which is still currently in trial. Then, at regional level, I will mention the Brussels Convention abolishing the legalization of documents in the member states of the European communities, which completely abolishes the legalization of the public deeds between the member states, and also the several regulations of EU, which names you can read on this slide. And it's important to say that according to these regulations, the deeds that are going to be submitted in the executive procedure require neither consular certification nor a similar formality. Then at bilateral agreements, I will mention them by bilateral agreements, which usually refers to legal assistance in civil and criminal matters or to mutual legal relations. The need for legalization of deeds in legal relations between two contracting states is abolished. The problem is that some of these bilateral agreements explicitly mention the public notarial deed, some of them not, and this in practice sometimes poses difficulties. This is the case of Republic of Macedonia too. I will skip then this summarizing point, and I will go to the second question, which is notarial deeds as enforceable title in international legal relation. Unlike court decisions and settlements, which acquire the effect of res judicata, the notarial deed does not acquire such an effect, since they always must be verifiable in additional court procedure. But this does not mean that the rights arising out of the notarial deed cannot be enforced. This possibility arises out of the effect of enforceability that certain notarial deeds possess. According to this effect of enforceability, of course, there are differences between countries. In Latin notary countries, enforceable notarial deeds are efficient alternative to court proceedings and the excellent instrument for quick and efficient legal enforcement. While the common law countries have not implemented the progressive institution of the enforceable deed in their legal system. First, to ask the question when the notarial deed is an enforceable instrument. The notarial deed is an enforceable instrument or title when it contains or if a certain obligation for acting on which the parties may agree is determined in the deed. And second, if it contains a statement or declaration by the debtor that on the basis of the deed, enforcement for the realization of the action after the obligation is due can be conducted directly. When we talk about the notarial deed as an enforceable title in international legal question arises whether foreign notarial deed have the effect of enforceable title and are directly enforceable in other countries, or, in other words, are the legal provision of the country of origins that confer enforcement effect of the notarial deed significant per se and for the enforcement organ of the other countries. First, I want to stress that the internationalization of the notarial deed, and in particular their cross-border recognition and enforcement, assumes a fundamental trust in the quality of the notarial function in general and in the notarial deed in particular. Regretfully, I must state that despite all the globalization and mutual interconnections, even today, the legal effects of notarial deeds, especially its enforcement effect attributed to it in its state of origin, does not automatically extend to foreign states, especially not in those in which the enforcement should take place. This means that the basic principle in international enforcement of enforceable deeds is still necessity of the enforcement declaration. Still, it's worth to mention that there are a lot of steps for providing that execution can be conducted without a prior issuing of a declaration of enforceability. For example, within EU, according to some regulation 44/2001, regulation 805/2004, the recognition and enforcement of notarial deed in all member states is only subject to very few formal requirements. And now I will proceed to the third question, which is composing notarial deed in matters with cross-border elements. It is well known that as a consequence of the sovereignty of the country, the activity of composing notarial deeds can be conducted only on the territory of the state in which the notary is appointed, and this means according to the territorial principle. When the notary takes activities or actions within his country of origin, his area of activity is not limited on account of the international connection of the subject matter of his notarization. Furthermore, the international element cannot be a reason for the notary to refuse to prepare a notary act. For example, if the object of the transaction is situated abroad, or if the person involved in the transactions are foreigners or have domicile or registered office abroad. Regardless whether the relationship in question has international element or not, the principle lex lotiacus applies, and this means that while preparing notarial deeds, the notary takes into consideration the rules for preparation of notarial acts in the country of origin. Taking into consideration that in certain cases the notary deed should produce legal effect in foreign countries, the autonomous notarial law make efforts to facilitate the composing notarial deeds in matter with cross-border elements by establishing the basis for international legal assistance for notaries of different different countries, and by introducing the principle of assignation of the notarial deed, which gives the notary right, apart from the domestic law notary, to respect the substantive and procedural as well as the collision provision of the country in which the deed will be used. And this provides that the notary deed, in formal and in substantive sense, is composed in accordance to the requirements of the country where it is going to be used. And at the end, just few concluding remarks. No doubt, the notarial deeds are the fundamental instrument of international legal relations, which provide for greater legal certainty in international transactions. The legal regime of notarial deed in international legal relations is still burdened by numerous rules. I mentioned lex loci, then legalization and or its substitutes, reciprocity and others, which are all expressions of the sovereignty of the country where the notary works, and they generally weaken the confidence in the foreign notarial deed. That in turn is itself consistent with the reputation that the notary has as a service in which the citizens generally express the greatest confidence. So, in order to increase the external efficiency of the notarial deed, it is necessary, first, continuously to work on the abolition of the legal barriers which prevent the cross-border relations with notarial deeds, and in practice to decrease the skepticism and to strengthen the principle of faith in foreign notarial deed to the extent that does not threaten the public order of the country where the foreign notarial deed is going to be used. Thank you.